So I think I will exercise my prerogative as the moderator to ask a question, and I'll direct it primarily towards Professor Burbank, but of course any of you are welcome to jump in. I'm wondering what is left of heightened pleading after Twombly and Iqbal. So we've heard the term heightened pleading bantered around quite a bit here, and we know that it exists in its actual form in Rule 9b, and also in the PSLRA, and that's where plaintiffs are required to plead with particularity when they their cause of action involves fraud or mistake, or in the PSLRA for certain securities class actions. But Professor Burbank, you mentioned that in some of the decisions you've been reading, particularly from the 6th and 11th Circuit, that those lower courts seem to be invoking or applying a heightened pleading standard. So I was wondering if you've noticed any difference between the heightened pleading standard as we know it in its formal sense from Rule 9 and the PSLRA, and heightened pleading in the more sort of informal or colloquial sense that some people have said Twombly and Iqbal implies. As we've seen, there's tremendous disagreement about what exactly those cases mean and what they require, and is it heightened pleading. But what is it that you've seen in the lower courts?
I think what I've seen in the lower courts is largely what was going on in a number of lower courts prior to Twombly and Iqbal, and it is occurring because of the power that the court now has formally given to the lower courts to disregard certain allegations in complaints as conclusory. The greater the freedom of a district court judge to disregard allegations in the complaint as conclusory, the more facts, sparing my colleagues' presence, the more facts that district judge is requiring. Now, the district judge, if taxed with requiring heightened pleading, would say, no, I'm not requiring heightened pleading, that's different. Well, I mean, I'm not so sure that it is different. The point is that we are, I think, without admitting it, getting back to a system of fact pleading, very much like the one that was explicitly rejected by the people who wrote the federal rules. Now, that may be what we need to do, although do note, in connection with one of the points that Professor Sherry made, whether there are problems in discovery and whether there are problems that are sufficiently great to concern us. So it is rather bizarre to me that we should approach it in this way. But note that the result is that people with putatively meritorious claims who don't have the ability to get the information because it's in the defendant's files, or don't have the ability to get the information because their lawyer is working on a contingency and doesn't have the ability to spend the fortune that would be required to discover the information without formal discovery, won't be able to come up with it. So we are getting fact pleading, and whether you want to call it heightened pleading, I don't think really makes any difference. It's requiring many more facts in complaints to survive a motion to dismiss than were required prior to Twombly and Iqbal by the Supreme Court, although not by some lower courts.
Actually, I think it's worse than fact pleading. I mean, and worse in the following
because
sense.
Because of plausibility.
Well, yeah, I mean, I don't think we're getting fact pleading. And if we were, I'm not sure what I would think about that. But at least we know what fact pleading is, because we lived with it for 100 years or so. The bigger problem with what we've got now is that we don't know what it is. It's something completely new. It's plausibility, whatever that means, and conclusory. And I, to some extent, maybe the idea of conclusory is going back to distinguishing between facts and law, but I don't think that's all of it. What I think we've got, and here I think Suja is right, is that we've essentially got early summary judgment. We've now got summary judgment before discovery. Judges are evaluating a complaint and looking at it and saying, do I think this should go to a jury, yes or no? And that's what they do with summary judgment. only it's now moved back to before discovery. That's not a system we've ever lived with. Whether it's a good system or not, it's just creating disruption because we don't know what it is.
And, I'll add to that a number of complaints now are, 30, 40 pages, which kind of seems to indicate that that's the kind of analysis that's going to occur now.
And it goes great to what one of your points, Suzanna, about about how the costs may well go up, right? Because now plaintiffs have the incentive to pack everything they can into these complaints in the hopes of satisfying this amorphous standard. And lo and behold, if they make it past that, now the defendant has to answer every single one of those allegations, and there could be hundreds of them. Are we really ending up ahead here in terms of costs?
Other questions? Well, it is just about 3:15, so despite starting late, I have you all back on schedule. Thank you very much to our panelists.